very special role that I was not part of the regular kind of stream. So therefore, the police were always skeptical, those investigators. Everybody around me was always, not exactly tuned whether the prosecutor would move in this direction or the other direction.
Welcome to the Bombay Bar Association podcast series. I'm Chetan Kapadia, and I have the pleasure of hosting a distinguished and respected legal luminary, former Chief Justice of India, Justice Uday Lalit. He holds the distinction of being only the sixth lawyer to be elevated directly from the bar to the Supreme Court bench. Join me as we dive into his revered and illustrious career to be awestruck with his journey of life and law. So in your flutter, in your early years at the Bombay High Court, of course, working under your senior Mr. M.A. Rane, which other legal stalwarts did you assist, interact with, which are great memories which have remained with you over the years?
See, when I was doing my law, in those days, Antule trial used to go on. So, not exactly the trial. It was that civil writ petition which was argued by Ashok Bhai before Justice Lentin. So as a student, I used to follow that. Then by the time I became lawyer, there was one heavy matter which Ram Jetmalani was arguing before, I think, Justice B.C. Gadgil. It was that Sharad Birdichan Sarda, which was a death sentence given to somebody from Pune, which finally was upturned by Justice Fazal Ali in Supreme Court, and he was acquitted. So that was one major matter which was going on. And then, of course, Antule trial as such, which Jetmalani started doing it before Justice Khatri first, then P.S. Shah. So therefore, those were the matters that we used to sort of, be looking forward to listening to some of those stalwarts. But above all, was that escorts matter, which Fali Nariman argued initially before S.K. Desai, and then finally before the Chief Justice, Konda Madhav Reddy, sitting with Rege. So therefore, these were some of the matters which I still recollect from my junior days here.
So then I want to tap your memory a little more at the present moment. I read a reference that your grandfather, pre-independence, chaired two events, one for Mr. Gandhi and one for Nehru. Can you tell us something more on that? Because in the external space, in the domain, on the internet, etc., there is very little material on it. And I'm sure you can tell us much more about it.
See, my grandfather in his young days, was an associate of Lokmanya Tilak. After the death of Tilak, he shifted to Solapur and set up practice. So he started practice in the year 1920. He was also one of those rare specimens who was part of the educational institutions, and education as an activity was something which was very dear to him. My grandmother was taught and became the first lady doctor of Solapur after marriage. So therefore, that's what the kind of, the education as an activity, as a flame, as something like a spark was always there. So he was well respected in Solapur. In those days, there was no elected panchayats or nagar parishads or municipal council. So as a part of the freedom struggle and as a part of the movement, when Gandhi once and second time Nehru visited Solapur, naturally you would have some kind of a satkar which is done from that very city. So that felicitation which was done by the city, they found my grandfather to be the ideal person to chair the occasion. So therefore he was, he was not holding any post as such. He was not holding any office. But he had chaired those two sessions when civic reception was given to Gandhi first, and then Nehru on the second occasion. That was only because he used to command tremendous respect from the residents of Solapur. So therefore, that perhaps was the recognition of that.
What kind of influence did you feel from your father? Because your grandfather was a lawyer. Your father was an eminent lawyer. As a young man, what kind of influence did their being lawyers affect your thought process of what you wanted to do in life?
Frankly speaking, as a child, my father had very little role to play in my upbringing, because as a young lawyer who wanted to set up everything in Mumbai, so he had come all the way from Solapur, had set up practice here to establish himself. He was all the while busy. So therefore, my picture of my father in my young days was somebody sitting at the desk, working all through. Even at night time, when you see he's still working. So therefore, that's the vision which I have of my father. If you see this Sirvai's book, there's a dedication by Sirvai, and what he says is, this book is possible. Why? Because my wife and children gave up the time which rightfully belonged to them. Something like that. I don't recollect the exact expressions, but it is in that vein. It's the similar thing. For every young lawyer who wants to establish, there are times are not so easy. There are difficult times. So therefore, my vision of my father, as I told you, was this. But what happened is, after he became judge, he lost his judgeship in the year 1976. After completing 2 years, he was not confirmed. I had not seen him when he was sworn in as a judge. I had never seen him as a lawyer. I had never seen him as a judge. But when the news started trickling in that Justice Lalit is not going to be confirmed, and so therefore 16th of January 76 would be his last working day. So I went to the court on 16th and I saw him for the first time sitting there on the bench in those robes. And that's what, that was my first entry to any court of law. So therefore, that was my father's last day as a judge, and that was my first day as even a spectator or an outsider or a student to enter the annals of court.
So, can you give us some insights about your time in Mr. Sorabjee's chamber and your initial days in Delhi?
See, it used to be a very, very busy chamber. We were, to my mind, 3 or 4 juniors around that time. Persons like Harish Salve and others, they had graduated, they had gone out of the chamber, they had passed out. So therefore, they were on their own. So in my days, it was Nisha Bakchi, Ujwal Rana and I, we 3 of us, and Rajan Mahapatra. 4 of us were juniors to Mr. Sorabjee. So on any given day, on a Monday or Friday, he would have something like minimum 12 to 16 matters. So therefore, divide those matters amongst yourselves. Then work on those matters. So therefore, my Saturday and Sunday would actually go in working. So my wife used to complain about that your attention is more focused on your law. So I used to tell her that law is a jealous mistress. So therefore, yes. But that's how every family actually has to go through that level.
So one of your notable cases was the resolution against Mr. Amrinder Singh in Punjab. And you single-handedly argued what Vidhan Sabha can do, what it can't do, what is the extent of legislative power, executive power, and the ability of courts to examine it and judicially review it. What was the strategy you applied to be successful in that case?
See, I had appeared for Captain Amrinder in some of his criminal matters. So when he was out of power, the next government had launched certain prosecutions against him. So therefore, he was on the verge of getting arrested. So therefore, his bail applications and so on and so forth, which I had done on a number of occasions. And suddenly the instructing lawyers said that very well, there is one resolution which has been passed by the Assembly, which is a very peculiar case, that the Assembly in question, when he was the Chief Minister, was dissolved. So therefore, whatever decisions he had taken as the Chief Minister in his executive capacity, because he was having the portfolio of what is called the urban development. So therefore, he had granted certain concession to a builder, saying that very well, you can set up a colony here, have this particular thing. That was, I think, Ludhiana or some such place where the permissions were granted to that builder. So therefore, decisions were completely in his executive capacity. After the dissolution of that assembly, new assembly, when it took over, it was the change in power. So therefore, rather than Amrinder, it was the party in opposition who was now was in power. So therefore, they had the majority behind them. And what they did was that they said that according to the resolution, the kind of allotment of that plot which was done to that builder when Amrinder was the Chief Minister in the erstwhile assembly was breach of privilege of this assembly. So therefore they passed a resolution saying that very well, for breach of privilege, Captain Amrinder be removed from the office. So therefore the remainder term will be something which he will not be able to enjoy. So therefore that case threw up too many questions. Number one, first of all, whether an act which is done in executive capacity by a minister, correct, whether will it be something which may amount to breach of privilege of the assembly. Because the assembly has not been kept in dark, nor has there been any kind of misrepresentation so far as the assembly is concerned. If you consider some of the earlier cases, like say vote for cash, Raja Rampal, where everything had happened so far as that house is concerned. Correct? You take bribe money. Why? Because you're supposed to be asking questions, or for asking questions you are taking money. So therefore everything is happening in and around or the conduct of business of that assembly. Here everything had happened completely outside. Secondly, whatever was done was in the previous assembly. So therefore, whether you can do it here now, the second time. So therefore, that's why it threw up challenges. Number one, executive. Number two, what is called the House powers or privileges of the House. So therefore, we filed a writ petition in Punjab and Haryana High Court, where, of course, we wanted to have the stay of that resolution. The High Court declined to grant stay. So therefore, we filed an SLP in Supreme Court. At the Supreme Court level, the matter came up before Justice S.B. Sinha, and he immediately on the very first day said that the matter requires to be considered by a larger bench. So that's how the matter came up before a bench of 5 judges, presided over by Justice K.G. Balakrishnan, the then Chief Justice. So therefore, then an independent writ petition was also filed. So therefore, this is how the perimeter of that matter was. So therefore, it was definitely a good matter to deal with, good matter to work on.
So yes, piloting this matter was very interesting, but you've been very different as a lawyer is what I noticed talking about you to people, reading about you. The court has always considered you as their own lawyer. There have been cases and cases and cases and cases where the court has asked you to address them, to assist them, to be amicus, and bestowed responsibility upon you as you bestow on somebody you consider your own. One of the big ones in that list is the 2G matter. Can you tell us, from your perspective, everything about the 2G matter?
2G matter in terms of sheer volume was very scary, because I think about 2 lakh pages or some such thing, so many exhibits, so many sort of, documentation and other things. And as you're aware, perhaps around that time, there was this litigation which was filed in Supreme Court, correct? I think Prashant Bhushan had filed that public interest litigation. And as a result of that, whether the Supreme Court wanted to consider whether the monitoring be done or whether some kind of, directions be issued. So therefore, at some stage, yes, a bit of monitoring was also done, whether charge sheets are filed or whether not filed, or etc., etc. So the first stage, Supreme Court ensured that charge sheets are filed. After that came the next stage. Once the charge sheets are filed, who conducts the prosecution? So on that score, there was a lot of debate in Supreme Court. And somehow my name was suggested by, I don't know who suggested it, but it came through that particular order saying that, yes, we would like Mr. Lalit to be the Special Public Prosecutor. So I was not a part of what is called the regular stream of public prosecutors, but I was appointed by the Supreme Court. And perhaps this was the first time that a public prosecutor was appointed by the Supreme Court to ensure what is called, free trial, or trial which is completely free from any influence. So therefore, my role was slightly, a very special role, that I was not part of the regular kind of stream. So therefore, the police were always skeptical, those investigators. Everybody around me was always, not exactly tuned whether the prosecutor would move in this direction or the other direction. So I'll tell you one of the ideas that, for instance, after Sanjay Chandra, 6 months, I immediately said that if Sanjay Chandra is the law, then every accused should be given, immediate relief after 6 months. So therefore, this perhaps was not the idea which a regular public prosecutor would have done that. So therefore, it was a different experience altogether. At the same time, it was very engrossing that a matter of this dimension, which was so bulky, and yes, one had to, live up to that. So therefore, I'm fortunate enough that I could do that.
After 39 successful, illustrious and busy years at the bar, you went to the bench in the Supreme Court. What really prompted you to change from a lawyer straight away as a judge of the Supreme Court? And what are the factors which weighed in favor of becoming a judge?
I went to see my father sit as a judge. So that perhaps had left an imprint somewhere in the deeper recesses of mind. And I thought perhaps, yes, this is also one idea which, if it comes my way, I'll certainly accept it. I must tell you that I had so many instances of conversation with my wife on this issue. Because there are certain signals which keep coming, though finally, of course, yes, it is put to you. But there were signals coming in previous years as well, 3-4 years earlier. Like one of the judges had asked me, what is your age? And I said, I'm 52. He'd done his nose like this, you're too young. So therefore, but then the piece of advice which came was, if it is offered, please don't say no. So therefore, that's how. So some of these judges keep talking to you. So therefore, it was perhaps the signals were coming through. And so I had chat with my wife, and I told her that yes, if it comes through, I am going to accept it. So finally, when it was offered, I did not even consult my wife. I said yes first and then told her that this is what I have done. So it was, yes, transition was there, but I was prepared for that.
Your being a successful lawyer, how did it help you in your changed role of adjudicating matters?
I had done matters from different ideas, different political philosophies, different kind of, whether in some matters I used to be prosecutor, in some matters I used to be appearing for defense lawyers. So therefore, I have had exposure from every possible facet of the matter. So therefore, as a judge, you're right as a lawyer that all you do is you just argue your bit. You're not bothered as to what exactly would the judge then be considering. Of course, you take care of it when you place the matter.
You factor it in.
But once the judgment is reserved, you have no control over it. What goes through the mind of a judge when a judgment is reserved, because the judge has to have various ideas to be kept in mind. Number one, not just deciding the matter, whether what will be the fallout of that, what will be the sequitur of that, what will be the effect on the future generations, what will be the effect on future kind of, similar matters which may come before the court. What will be the idea for the lower courts, whether will it be possible for them to follow this. So therefore, these are some of the ideas which a judge has to keep that in mind. But you're right, as a judge, you have to see both sides and then find the balance and fine-tune the matter.
In your tenure as a Chief Justice of India, you prioritized listing of cases. You looked into systems and worked on changing them in a way that constitution benches took up cases, bail matters were taken up, and a variety of several kinds of cases which needed urgent attention but which were languishing from ages were taken up. What were the priorities which you placed in your mind to do that?
See, unfortunately, what happened is during COVID times, the disposal of the cases in court had come down, which in effect had a spiraling effect so far as the pendency and the backlog is concerned. So therefore, we as a court were struggling with backlogs. Number one, as a fact. Number two, there were certain kind of matters. What happened is that, say for instance, death sentence matters. Now, before that judgment which was rendered by Justice Rohinton Nariman, saying that all review petitions in death sentence matters be listed before a bench of 3 judges. Before that, these matters used to come before a bench of 2 judges. In Supreme Court, normally what happens is you divide the number of judges who are available on a particular day and then create benches. If there is an odd man out, then it becomes a 3-judge bench. At best, there may be two benches or 3 benches of 3 judges, not more than that. But then as a fallout of that Justice Nariman's judgment, on the administrative side, a decision was taken that if the review bench has to be 3 judges, the initial bench also has to be 3 judges. Logical?
Yes.
So therefore, all death sentence matters would start getting listed before a bench of 3 judges. But if you have only one bench which is 3 judges combination, how many death sentence matters can you list before them? So therefore, again, a restriction. So by the time I took over as Chief Justice, there were about 55 matters where death sentence was given, were pending consideration. So therefore, that was one part. Then there were, because in those 2 years of COVID-affected era, constitution benches were not sitting, because through virtual mode, it becomes easy to dispose of normal routine matters, not the constitution bench matters. So therefore, those matters had also piled up. So when I took over, strength was 30 judges. So therefore, the day I took over, I had called a full court meeting so far as all my brother and sister judges were concerned. And then we decided that divide 30 by 5. So there were possible 6 combinations of constitution benches. So I will have 6 benches of 3 judges and 6 benches of 2 judges, which means 18 on one side and 12 on the other. That means 30. So one combination of 3 judges and another combination of 2 will come together to form a CB, Constitution Bench. Otherwise, they will sit in combinations of 3, and then those death sentence matters will get listed before them. So therefore, instead of just 1 or 2 windows of exposure, now the death sentence matters will have minimum 6 courts which are available. So therefore, there will be more exposure and more possibilities of the matters getting disposed of. So therefore, in the process, what happened is, instead of having a constitution bench only in court 1 or 2, now number 6 court judge would also be heading a constitution bench. So therefore, this is what I thought of. This is number 1. Number 2, there were also about 3,000 matters which were transfer petitions on matrimonial side which were pending. And I think that's not a good idea. See, of course, it is not good to be having a dispute on the marital side, but if at all there is, at least, it should get decided as early as possible so that there is life ahead of that man or the woman so that he or she can lead that life. But if you are still struggling in Supreme Court for three years as to which court, whether I am in Chennai and the husband is in Delhi, which court is going to hear the matrimonial dispute, that's not a good sign. So therefore, I said that very well, these matters must be disposed of at an early date. So therefore, I categorize death sentence matters, and of course, those matters which are wherever there is personal liberty issue. So therefore, those must get listed immediately.
Another impeccable progressive step which the Supreme Court took, and now it has, as a result of your initial efforts, trickled down lower, is pressing the accelerator on live streaming of court cases. Though the decision to do so was taken many years earlier,
on the judicial side, you really pushed it and made it happen. And when you made it happen, all stakeholders got comfortable with it. I'm sure that internally you must have faced resistances, differences of opinion, and you stood nonetheless by it. Can you tell us a little more on There were no differences or there were no obstacles as such. See, as you rightly said, the decision was already taken on the judicial side, number 1. Number 2, what happened during COVID times is that because we turned virtual, so therefore, when you turn virtual, somebody sitting in, say, Tiruchirappalli or even in Srinagar can get connected to and can attend the hearing in Supreme Court. So therefore, for him, what goes on in Supreme Court, he can watch it sitting there at his place. Now, when you want to live stream it, it is the same idea, the same grain, but at a different level, at perhaps the proportionately at a higher level. Second idea perhaps of live streaming is this. See, as a youngster, I still, you see in the books what Sirvai argued in Keshav Singh, in the special powers of the Assembly as against the High Court of Allahabad, and also in Keshwanand Bharati, you only read in papers or you read in books. In today's generation, you can also sort of preserve it for the next future generations as to how a particular matter was argued, how the matter was dealt with by the judge. And that is possible when you have this live streaming. So therefore, people can record it, people can preserve it. I keep going and giving lectures in a law college. Those law colleges have preserved all those, now some of the new decisions which have been rendered by the constitution benches. So therefore, the entire argument. Now that argument is then put up before the students by way of a lesson. So therefore, this is something which is a great advantage of live streaming. So therefore, number one, virtual ideas which were planted as a seed, judicial recognition. I just went a step further.
Sir, on your note of dissent in the EWS decision, legal thinkers, critics, and people with great experience in law have considered your dissent to be a profound logical thought and much more. Personally, even I feel that, that is how it should be. You were very convinced with it, and that's why you've written that dissent. But as a practicing lawyer, I would like you to give a few insights on the deep thinking which led you to come to that conclusion.
See, our constitution, right from moment number one, when it was brought into force, had contemplated two kinds of sections of people who required affirmative action and compensatory discrimination. Number one, scheduled caste. Number two, scheduled tribes. Of course, there was another category which was the Anglo-Indians, but for them nomination was very, very nominal one. Then we have, over a period of time, kept expanding that idea or the sections of the society which require affirmative action. Like 73rd, 74th Amendment, ladies got what is called 1/3 in municipal elections or panchayat elections seats. Then Mandal, OBCs got what is called, instead of 15 and 7.5% for scheduled caste and scheduled tribe, you added 27% more and came very close to what is called 50% barrier, 49.5%. So therefore, you had one more section of the society which got added by way of affirmative action. Children got, between the ages of 6 to 14, right to education as a compulsory kind of, free and compulsory education. Another section of the society got some affirmative action in coming in their way. All of this have some roots somewhere in the Constitution. So therefore, there are certain articles which actually speak of that. Like, for instance, if you turn to Indira Sahni, the very same logic which was advanced by some of the petitioners was that Constitution recognizes only scheduled caste and scheduled tribe. Where is this third category, which is OBC? And why create a reservation in their favor? But then the bench ultimately found it that the grain is actually in the Constitution itself. The roots are there in the Constitution. So therefore, you can give that. Now, the very same judgment, Indira Sahni, the office memorandum had also thought of 10% reservation for EWS. But that particular provision of the office memorandum was struck down by Indira Sahni bench, correct? So therefore, on one side, you accepted affirmative action or reservation or compensatory discrimination in favor of OBCs. But on the same side, you never accepted in favor of what is called EWS. Because EWS by very nature is what? For those for whom there is no reservation, which means you are neither scheduled caste, nor scheduled tribe, nor OBC, which is non-creamy layer. So if you are not any of this, but you are EWS, then you will certainly have the benefit of 10% reservation. Who can that be? It will be only forward communities. There is no other person who can answer that kind of description. So therefore, this was something which was struck down in Indira Sahni. Now when the occasion came, because now it was through the Constitution, the Third Amendment, which brought in 15(6) and 16(6). Therefore, the challenge was to that. One of the ideas which we as a minority, we felt was that there are poor sections in scheduled caste, scheduled tribe and OBCs as well. Why are you concentrating only on poorer sections in the forward communities and giving them the benefit of reservation? So therefore, you are on one side not allowing or neglecting poorest of the poor coming from scheduled caste, scheduled tribe and OBCs, but at the same time allowing the same benefit to forward communities. So therefore, there is an exclusion. And on that exclusion as a principle, this is what the minority then felt, that perhaps that may not be a good idea. But the majority felt otherwise. So therefore, the decision has gone 3:2. So therefore, for us, students of law, the final word is the majority. And the majority has accepted it.
In that limited time which you had available with you, you showed that magic and the numbers reflected that magic. We want to share that glee through your words, through your thoughts, and the satisfaction it gave you and your colleagues.
See, before, as in Supreme Court, what happens is Judge number 2 is normally in charge of what is called legal services. So Nalsa, he is the chairperson. He takes care of all the what is called legal service apparatus, everything, the entire regime. So I had taken over that office sometime in June of 2021, and I was holding that post for about 15 months till I became the Chief Justice. During those 15 months, what I saw was that there are, of course, huge pendency in courts, yes. Unfortunately, the disposal doesn't match the kind of filing which is done. One of the ideas to take the slice out of the pendency or the pending figures is through, like say, Lok Adalats, through other sources that you can actually sort of reduce the workload. Now, I'll give you another example. In Lok Adalats, which are normally done by NALSA, when I took over, the highest number of disposals on a single day in National Lok Adalat in pre-COVID area was 14 lakhs. COVID era was, of course, was a slight sort of reduction in those figures. So we took the virtual world as our ideas and started getting into that particular part. So I started holding conferences with all the legal aid chairpersons coming from the state, various high courts. We had meetings, South Zone, East Zone, West Zone, and so on and so forth. So as a result of that, first Lok Adalats we held was more than 14 lakhs. The figures steadily rose, and the final Lok Adalat which I took when I was still chairperson, the disposal was more than 1 crore and 10 lakhs on a single day. So therefore, this is the kind of, the slice that we were able to take out of the pending matters. Now, part of it are pre-litigation work, part of it is post-litigation also. So to the extent it was post-litigation, overall figures of whatever is called pendency were getting reduced. Now, coming to the Supreme Court, what after my, as Chief Justice, I had the privilege of having the first full court immediately. The day I was sworn in on a Saturday, so it was not a working day. So that very day, we had a full court meeting. So therefore, even before I started my judicial discharge as a Chief Justice, there was a full court meeting, and we had certain ideas were firmed up. So I said that very well, these are some of the categories of matters that we need to dispose of. So therefore, it's with the support of everybody, all the benches, my brothers and sister judges, that we were able to achieve that. Yes.
Is it that your practice as a criminal lawyer and thereafter deciding a wide variety of cases on the bench on the criminal side helped you to shape up criminal jurisprudence in our country to a stage where the victim or the accused or every participant in the criminal justice system is treated with an even hand and gets a chance before verdict is delivered?
Look at the struggle that we have seen. Entire struggle of Supreme Court is what? What is Maneka Gandhi ultimately? Trying to see that every individual reaches the highest potential of his or her own capacity. So therefore, it has always been the struggle that very well, to the extent possible, give the maximum scope so far as individual rights are concerned. Speaking of criminal law, there are, of course, 3 or 4 kinds of, ideas which flow. Number 1, of course, the prosecutor. Number 2, the accused. So therefore, protect the rights of the accused to the extent possible. So as a legal aid chairperson, we started what is called the Public Defender's Office. So just as Public Prosecutor's Office in a district, now there will be Public Defender's Office. So therefore, rights of the accused must be protected. So therefore, that's number 2. Number 3, victim. So therefore, his or her rights must also get protected. Now, there could be possibly, say for instance, acid attack cases. There could be situations where immediate succor is required. So therefore, the state must be made to compensate that victim.
So the attention which you just spoke about, there was national attention to a case decided by you. That is the sexual assault skin-to-skin contact principle case. Because it is such a sensitive topic, how did you approach it?
See, the very subject itself was something, of course, the judgment is rendered by Justice Bela Trivedi. I was part of the bench, so I was presiding over the bench. But imagine if you touch a girl or a woman through the layer of a clothing apparel that she is wearing, and therefore you say that my finger or anything hasn't touched her skin. So therefore it is no skin-to-skin contact and therefore no undue advantage. It doesn't sound rational, logical or correct. So therefore, the whole concept is what? To protect the dignity, majesty, and sort of, protect that girl or protect that child. So therefore, any assault which theoretically may be through, the layer of a clothing apparel and therefore not skin to skin as such, perhaps may not be a good idea when you think of some of the sections of the criminal law and assault sections. Of course, yes, when you want to say the actual act of commission of rape, you will certainly go by that. That's a different connotation and different context altogether. But taking, say, undue advantage of a girl, trying to grope or touch her, one need not have skin-to-skin contact. You will still be violating the dignity of that woman. And therefore, to us, it sounded very, very illogical. And that's why the judgment was rendered.
So I say this because the jurisprudence propounded by your lordships in that judgment is now a guiding light in deciding all POCSO cases all over the country.
Yes.
And the principle on lenity also, which was laid down by your lordships in that judgment, has changed the landscape so far as several provisions are concerned.
See, POCSO is what? Ultimately, a immature or a minor girl should not be sort of taken advantage of, undue advantage. And that is the reason why there are vulture-like people who try to take advantage in various ways. The ultimate way will be to outrage the modesty by actually committing a sexual assault. That's a different thing. But there are various stages as well. And that will definitely be outraging the modesty of a girl. So therefore, if your law has to be effective, law has to be protective so far as the rights of that minor child is concerned, then you have to devise a way in which the protection can be guaranteed and can be ensured at the maximum level. And that is why this particular logic, which is skin to skin alone would be punishable, perhaps we did not find any logic in that logic.
Where do you think the judiciary should do a little more in trying to transform society, make it move ahead?
See, it's not just the judiciary, it's the concerted effort of everyone. I'll put it at the legislature as the first step. Now, take for instance, 138 Negotiable Instruments Act, check bouncing cases. How much of impact assessment was done by the legislature before it engrafted that as a provision? So therefore, nobody thought of that, in today's world, half of the criminal litigation in lower courts is nothing but check bouncing cases. So therefore, one single provision has given rise to so many kind of, avenues where perhaps people would rush to the courts, and the kind of avalanche which it has created or generated was perhaps, I think, beyond the expectation. So therefore, that's number one. Number two, now take for instance Supreme Court. You have 136 which is purely discretionary. But you have created so many statutes like say Electricity Regulation Act, Consumer Protection Act, Armed Forces Tribunal Act, Central Administrative Tribunal Act, where a right of appeal is directly to the Supreme Court. So therefore, on one side you say that very well there is, dependency should be less. But the statute itself actually generates so much of litigation. So therefore, number one part is perhaps I think when you enact legislations, one has to be very, very sure where exactly you are embarking, in which direction. So therefore, first idea is that, try to minimize the scope of future litigation, number one. Number two, when it comes to judiciary, the superior judiciary should actually concentrate on that kind of matters which will lay down law for the generations and the courts to follow. Now, take for instance, if there be a very, very ticklish issue on the income tax side, and the matter stands referred to a bench of 3 judges, the moment the matter is pending, that will be taken as a ladder by thousands of matters to get admitted in Supreme Court. So therefore, one single matter produces a batch of 1,000 matters which get added. So therefore, for you must actually locate that matter and dispose it of as early as possible, which will then thwart, the new coming sort of, 1,000 matters. So it will actually sort of keep the entire pendency at a low level. The second part. Now, supposing in case you have a criminal matter, where because of the gravity of the situation, the fact that it's a gruesome murder, so therefore you don't release the person on bail, so he's languishing in jail, how long? After 5 years, if he comes with a prayer for bail, what will you do? Very well, you may reject it. 7 years, somewhere along the line you will have to check and balance it with that individual's right as against the rights of the society. So therefore, what is the solution? Dispose of the pending appeal as early as possible, which will then take care of and will not generate future bail applications, which will keep adding to your roster, which will keep adding to your calendar. So therefore, one has to do that case management ideas within the court itself.
So, well, that's a great learning, sir. And therefore, I want some closing remarks from you. Closing remarks which open doors and windows for people like me, lawyers like me, and young aspirants. When do we get to read a book or a few books written by you? when do we see you in public life doing things in official capacity or in some capacity which some people as eminent as you take up?
I've already completed 4 terms of teaching at Jindal Law School, 3 terms in another law school, and 2 terms in at least about 4 different law schools. So therefore, I have taken up what is called teaching, and I love teaching. That's one idea where perhaps whatever I have learned over a period of time, 40 years, 40 plus years in the field of law, diverse experience as a lawyer, as a judge, I try to put it across through my lectures to the students. And I teach various topics and levels. Like, for instance, I just completed a course in one of the law schools which was on 3 new legislations which are on the criminal side. Bharatiya Nyaya Samhita, etc., etc. In the other law school, I teach them what is called affirmative action under the Constitution. So therefore, as diverse topics as possible. So therefore, that also keeps me on toes, constantly sort of puts me engaged in some engrossing work. At the same time, I have the pleasure of, giving it back to the society in the form of maybe lecturing young students. If they learn from my experiences, that's icing on the cake.
Thank you. Thank you.
Thank you so much. Thank you.